What happens when California can dismiss your essential suppressor as a mere accessory and suddenly make you a felon for owning it? What then stops them from aggressively pursuing your recoil pad, your optic, or anything else that makes your rifle safer and controllable right now? The chilling answer lies in Sanchez versus Bonta, where 3 judges on the Ninth Circuit are urgently reviewing California Penal Code Section 33410, the state's total egregious ban on firearm suppressors, a ban that even ensnares citizens who would be perfectly lawful under federal NFA rules, and runs directly counter to the spirit of the Hearing Protection Act. On November 18, 2025, state lawyers stood before that court and brazenly argued that suppressors aren't even shielded by the Second Amendment because they are not arms at all. In this emergency video briefing, I'm going to walk you through the dangerous arguments those judges actually heard, how the explosive cases of Bruin and Duncan versus Bonta shaped this confrontation, and what is truly at stake for ordinary gun owners far beyond California's borders. Let's slow down and dissect Sanchez versus Bonta step by critical step. After this breakdown, you will be fully equipped to explain this complex, high-stakes case to anyone at the range or dinner table without needing a law degree. We're going to unpack the key players, the punitive law California uses to turn a quiet piece of metal into a felony, and the alarming maneuvers that unfolded inside that Ninth Circuit courtroom. Gary Sanchez is not some fictional cartel hitman. He is an ordinary, law-abiding American gun owner who sought to do something that is perfectly legal in the vast majority of the country: own a suppressor after strictly following the federal process. The problem, the legal poison pill, is California Penal Code Section 33410. That statute does not merely regulate suppressors. It does not license or tax them. It issues a flat, unconstitutional ban on possession. If you possess a silencer in California and you fall outside a narrow government carve-out, you face a terrifying cocktail of consequences: a felony charge, potential prison time, a ruinous large fine, and the likely permanent loss of your fundamental gun rights. Now, contrast this with how the rest of the federal system treats suppressors. At the federal level, under the old, burdensome NFA rules, suppressors are tightly controlled, but they are not outlawed. You pay your taxes. You submit fingerprints and extensive paperwork. You wait for the federal bureaucracy to approve it. Then, and only then, you can legally own one. Crucially, Congress has been moving toward making suppressors less restricted, not more, through the federal package many know as the Hearing Protection Act, which is designed to cut the punitive tax and bureaucratic red tape around suppressors. Therefore, at the exact moment the federal government is moving toward deregulation and recognition, California is dug in on a total draconian ban. That toxic clash, federal permission versus state felony, is the ignition point for this entire lawsuit. The district court, the initial stop in the federal system, effectively looked at all of that and shrugged. The judge declared, in essence, a suppressor is not a weapon. It doesn't shoot anything. It's not armor. It's just an accessory. Because of this, the judge reasoned, it is not an arm in the sense the Second Amendment protects. That is precisely how the court attempted to dodge the modern, mandatory test the Supreme Court established in Bruin. If you recall the core rule from Bruin, the court must ask 2 crucial questions. Does the plain text of the Second Amendment cover the person and the conduct? And if it does, is there a historical tradition of this specific kind of restriction? The district court tried to stop the inquiry cold at step 1 by declaring, no, silencers aren't covered at all. Thus, they never even had to consider the history. That legal sleight of hand is how Sanchez was forced to appeal to the Ninth Circuit. So, what happened when this critical, high-stakes case finally went before the 3-judge panel on November 18, 2025? Inside that Pasadena courtroom, you witnessed 2 fundamentally different and opposing performances. On one side, the lawyer representing the state of California leaned dangerously hard into the idea that suppressors are nothing but optional add-ons. He explicitly told the judges that silencers are rarely used in crime, but can still be banned because they supposedly add a super-added danger when used by a criminal. At the same time, he cynically argued they do not count as protected arms, so the court should treat them like any other piece of gear that the state wants to eliminate. Here is where the argument becomes crucially important. The state's lawyer openly admitted that suppressors are rarely a factor in crime. You won't see that confession in any anti-gun headline. But instead of saying, "Okay, then this isn't a major public safety threat," he immediately pivoted and argued, "Well, they are still dangerous enough that we can ban all of them." To justify this sweeping, illogical power, he reached back to another notorious case from this same circuit, Duncan vs. Bonta, where the court allowed California to ban so-called large-capacity magazines. In that case, the court infamously described magazines as essentially optional parts that the state could single out and restrict. If you are hearing a pattern of legal sabotage, you are absolutely correct. The toxic maneuver is always the same. Relabel the item an accessory, argue it is not at the core of the constitutional right, and then claim the state can do whatever it wants in the name of safety. The fundamental problem is that this mindset dangerously resembles the old balancing test that the Supreme Court specifically rejected and outlawed. Instead of asking, is there a historical tradition of this kind of ban? The state wants the Ninth Circuit to weigh its speculative safety concerns against your enumerated rights and simply defer to the government. That is precisely what Bruin told lower courts they must not do. On the other side of the podium, the attorney for Sanchez appeared ready to fight fiercely under the exact rules the Supreme Court actually laid down. His first powerful point was simple. The arm here is not some inanimate metal tube sitting on a table. The arm is the firearm configured with a suppressor. And that combination is plainly a modern weapon used for lawful self-defense. When viewed through this lens, the plain text of the Second Amendment absolutely covers the conduct. You are a law-abiding citizen. You are keeping and bearing a firearm for defense, and you are choosing to do it in a way that responsibly reduces noise and blast. From there, he immediately pushed the court to do what Bruin demands: walk through the history. Is there any real American tradition of banning an entire category of devices that make shooting safer and more controlled for the law-abiding? Not regulating, not taxing, but outright criminalizing? That is a vastly different question from asking whether a state can pass neutral safety rules. And it is a question where California's defense comes up historically empty. There simply is no historical pattern where the government said, "You can have the gun, but we are going to criminalize the essential things that stop you from blowing your eardrums out or disturbing your neighbors." He also drove home a point that resonates with anyone who has responsibly shot a firearm with a suppressor. These devices are not Hollywood tools for assassins. They are hearing protection devices. They dramatically cut down the blast that can inflict permanent, life-altering hearing damage during home defense or necessary training. They reduce noise for people who live nearby, and in many responsible parts of the country, they are treated as exactly that: safety equipment that responsible shooters use to protect themselves and others. That is exactly why federal law is moving in the direction of reducing the tax and paperwork burden, not doubling down on felony bans. Next, at this pivotal moment in the argument, the judges began to pointedly probe the toxic logic on both sides, and that is where one of the most important, clarifying moments occurred. One of the judges essentially said to the state, "Under your reasoning, what is to stop California from banning recoil pads?" Think about the catastrophic implications of that question. A recoil pad does not fire a bullet either. It just makes the firearm more controllable and less punishing for the shooter. If the test is, could a criminal theoretically use this? Then there is almost no limit to what a state could demonize and outlaw. Night sights, optics, adjustable stocks, bipods, every single one of those could be portrayed as things that make a gun too effective in the wrong hands. That hypothetical was not a throwaway joke. It exposed the core, catastrophic flaw with California's entire legal argument. Once you agree that anything that helps the shooter is fair game for a ban, you have handed the state a blank check to strip away the practical tools of responsible gun ownership. The gun itself becomes a hollow, unusable right. You might technically be allowed to own a bare-bones, antiquated firearm, but everything that makes it accurate, safe, and usable under stress could be instantly reclassified as a dangerous accessory and outlawed. That is not how a genuine constitutional right is supposed to function in a free society. Now, I wish I could simply tell you this was an easy call, and that the panel clearly sided with Sanchez. The reality is far more complicated and fraught. Based on years of watching the Ninth Circuit handle Second Amendment cases, many of us are bracing for a split decision. You have a panel composed of judges with radically different views of gun rights. Some of them have already signed on to opinions that treat Bruin-related cases with a deep, dangerous skepticism. So, the honest, sobering assessment is this. There is a real, imminent chance we get a 2-to-1 ruling that upholds California's ban, even after a powerful performance from Sanchez's legal team. But that is not the end of the road. If the panel rules against Sanchez, his legal team can immediately ask the full Ninth Circuit to rehear the case en banc. That means a much larger group of judges would have a chance to take another, deeper look, especially if the panel stretches or misapplies the modern Second Amendment framework. And beyond that, there is always the possibility of asking the Supreme Court to decisively step in. The justices have already laid down the basic rules in Heller, McDonald, and Bruin, but they have not yet squarely answered how far states can go in banning things they simply call accessories, when those accessories obviously and directly impact how firearms are used for self-defense. So why should somebody in Texas, Florida, or Ohio care about any of this? Because bad logic travels at the speed of law. If California can convince the Ninth Circuit that suppressors sit outside the Second Amendment, other anti-gun states are going to immediately copy and paste that flawed reasoning into their own bans. Maybe it is suppressors first, maybe it is certain optics next, maybe it is particular stocks, triggers, or anything else they can label as extra and dangerous. Once the courts bless that insidious playbook, every new restriction becomes, "Don't worry, we're not touching your right to have a gun, we're just outlawing the things that make it effective." That is why Sanchez vs. Bonta is such an urgent, high-stakes deal. It is not just about one man and one silencer. It is about whether courts will let states use deceptive word games to carve out half of the modern shooting world from constitutional protection. In a moment when federal law is finally starting to recognize suppressors as normal safety tools, California is trying to lock in a felony ban and call it common sense. This case will tell us everything about whether judges are willing to enforce the text and history of the Second Amendment, or whether they are going to keep letting states treat your rights like policy preferences that can be edited away one accessory at a time. That is where Sanchez versus Bonta leaves us, a Ninth Circuit panel deciding whether suppressors are safety tools or felonies. If California wins, every accessory gets a target on it. Stay alert, stay engaged, and subscribe so you don't miss the ultimate ruling and what this means for your Second Amendment rights in the future.